SJC-11648, Stephen Fitzgerald v. Haverhill District Court, and another.
Mr. Fitzgerald, good morning. I'm going to turn your attention to that clock in front of you. You have 10 minutes, all right? And that clock will tell you it'll turn yellow with 1 minute to go and then turn red when your time is up, all right?
I know. I've been aware that I've only been given 10 minutes.
Right, and that's the same for both sides.
What's that?
That's the same for both sides.
I thought it was 15, but that's all right. This matter comes before you with some mental health concerns. And it's here, it's not. What Justice Spina said it was a Rule 30 where it was about to withdraw a guilty plea. It was for cruel and unusual punishment because of the forced medication. No court in this state could show you a valid order for the forced medication. The guilty plea was done under torture, and that's what it was done. I mean, the Commonwealth in their brief says that I didn't indicate that it was done under duress or anything like that, but it was done under torture. That's what it was. I've tried to address this in the courts, and I haven't had any help doing it. I'm trying to address it, and to make a person take drugs without any valid court order, I don't see how anybody couldn't see that that is torture. So I'm asking this court to vacate that because of the flawed process. Flawed process. There's time limits in these 123 hearings, and they were just completely ignored. Anytime I tried to bring that to the attention, I was stopped in the courtroom. I was found incompetent to stand trial on the 19th of October of 2012 without being in the courtroom. I don't know how that could be. I don't know how anybody could consider that not to be a flawed process. I wasn't in the courtroom.
You had an attorney for that matter?
I had an attorney who was appointed for me out of Haverhill District Court on the 13th, my first day in Haverhill District Court. I was extradited back from Las Vegas. In Haverhill District Court on the 13th, appointed attorney Anna Colonel Phillips, who requested that I be sent to Bridgewater. She did nothing to defend me. Within 5 days, she withdrew from the case. And I wasn't in courtroom. I wasn't brought back into the courtroom until November 8th, 2012.
And then when you came back, what happened with regard to your appointment of counsel?
I was appointed counsel, I believe, without being in courtroom. An attorney, Lee Graham, was appointed to represent me. Mr. Graham didn't come visit me didn't attempt to, until 28 days after a 20-day commitment. I was trying to get my case moving forward. There's time limits within this case that have just gone right out the window. And that was the basis of my motions, which I put into the court, which were completely ignored throughout.
And then after that, what happened?
After what? After the 19th, when Robert Diner, the medical director, petitioned the court to have me committed, I was brought into Brockton District Court on the 31st of October. And Judge Rosemary Minahan couldn't go through with the proceedings because the papers weren't properly filled out, and she knew that I wasn't in the courtroom. The case should have been moved forward. There's a defect in this process that everybody has just completely ignored throughout. Commonwealth is correct in saying that I don't have a complete record here. I don't. I've been told to get the fuck out of the clerk's office as recently as a couple of months ago on orders of an unnamed Chief Justice. I can't get in there to get this done. There's documents in here that I don't even have a right to have. They're under 12336A. They're private documents that a judge has to clear for a person to have. They're mental health proceedings. I picked one up in Brockton Court. It should be specific to Haverhill Court. When I brought that to the attention to the clerk over there, she doesn't know how it left that courtroom. There was never an order out of Haverhill District Court of the finding of incompetency. There was when I wasn't there by Judge Morey. When Judge Minahan brought up the floor, I was brought back into Haverhill District Court where it was vacated by Judge Darling because I wasn't in the courtroom. That time, this case should have went forward, and it didn't. Brought back to Bridgewater, kept in Bridgewater, where the time limits had come and gone, so they could correct the process. At no time have I ever had a hearing out of Haverhill District Court for competency.
So where does the case sit now?
Case sits now where I've pled guilty because of the torture.
And you say torture, torture meaning what?
I was forced to take drugs without any valid court order.
And did you appear before the judge and answer questions with regard to it?
At which time?
At the time of the change of plea?
Yes, I did. The first time when I wouldn't take the guilty plea, I was sent back to Bridgewater with the medication which they were illegally giving me was raised 500%. At that time, in February of 2013, I believe it was, I think it was the 1st, I had just found out that the Assistant District Attorney, Jana Di Natale, out of Essex County, was contacting Bridgewater. I have no idea why.
Now, what usually happens in such circumstances where somebody claims that their plea was involuntary for whatever reason is they move for do a motion for new trial under Rule 30 before the motion, before the judge who heard the plea to say that plea was not voluntary, and I ask you to vacate that plea of guilty, and if that judge denies it, then you can appeal that. Why have you not proceeded in that course?
I have done that. I put in my request for the record, and it was ignored. I was violated on probation. I was kept in the Shattuck Hospital in a lock. I couldn't get there. So my communications to the court were ignored. I was brought back into...
So you've tried, because Judge, you did present that motion to Judge Byrne, right? The Rule 30 motion in the Haverhill District Court, right?
There's a motion that was to get the record so I could put in a motion. I also put in a motion to a Stubbs motion, which the court received on July 15th of 2013. Wasn't heard until after this action was opened on the 14th of the February of last year. It takes me to write letters to the Chief Justice of the Administrative Court and to start an action in this case to get something going. 8 months went by before they even heard that motion.
And that was heard by which judge?
Judge Byrne, I think it was fact. It wasn't before me.
And what happened with regard to that?
It was denied. The Stubbs motion was denied. It was done at the request of the clerk's office of the Supreme Judicial Court, Suffolk County. I don't know who entered it in there. After the 31st of January of last year, when I put my motion in here, there were things that were entered into the 211-3 that I don't know why they were put in there. I just found out about them 2 weeks ago. That's my supplemental motion. I don't know if it's been acted on where I could add documents. I haven't even been given that opportunity. I mean, I've had motions in this court. July 17th, it still hasn't been acted on. The ex parte motion.
And with regard to the denial of your Rule 30 motion, have you appealed that? Because that would be done.
I haven't done a Rule 30 motion.
Sorry?
When I couldn't get documents out of Haverhill District Court, I brought the action, the 211-3.
But you did bring a motion in the Haverhill District Court. I was wrong to say it was a Rule 30. You brought a motion to vacate and reimpose your sentence so you could appeal? Or, is that right?
That was just to protect. That was in the court on the 15th of July of 2013. Wasn't even ruled on until February of last year, 2014. I have a motion that was in the court on the 1st of August, 2013. Hasn't even been heard in Haverhill District Court. I can't get anything done in that court.
But did you? But that motion was decided by Judge Byrne, I think, in February of 2014. And did you appeal from that?
I put in a notice of appeal, but I just depended on this action that was in that Justice Spinas denied, where he stated it was about a Rule 30. My action in the 211-3 had nothing to do with a Rule 30. It's about the cruel and unusual punishment by being forced to take medication. The guilty pleas aren't even valid.
But the relief you're seeking, I assume, is the vacating of that plea, or not?
They can't overturn the case. The time limits are mandatory. 123.16b says if a person is committed without first being found incompetent, the case must be dismissed. Dismiss them. I've been trying to do that for a year and a half. Anytime I try to get something out of Haverhill District Court, I'm stopped. I don't know who's denied the motions in this court because nobody tells me who they were. But I have a motion in this court, the next parte motion, to add documents, and nobody's answered them in well over 7 months. It was in this court on the 17th of July. You haven't answered it. It's not that hard to believe that Haverhill District Court isn't answering things in 9, 10, 11, 12 months. And there's been cases there's something going on for over a year and a half they haven't answered about the documents in which I had up there trying to get. I can't get any relief up there.
Okay, well, thank you. Let's hear from Ms. Foster if we can. I think you're, so Ms. Foster? If you would address Mr. Fitzgerald's concerns and tell us what you think is going on in Haverhill District Court.
I will. Thank you, Your Honor. May it please the Court, Chris Foster for Haverhill and Brockton District Courts. The sole question before this Court is whether Judge Spina abused his discretion or properly exercised his discretion in denying the petition pursuant to 211.3. And I think the short and simple answer is yes. As this Court's already pointed out, Mr. Fitzgerald has had other opportunities to, through the ordinary review process, to review his involuntary medication and his guilty plea. He could have reviewed his forced medication as long as it wasn't an evidentiary issue. If it was more of a concern about liberty interest, he could have appealed it immediately. That's explained in Commonwealth v. Collar in footnote 4. He also, under Chapter 123, Sections 5 and 9, 16C and 9B, all had opportunities to appeal this. And if he really is trying to vacate his guilty plea, of course, he filed his Rule 30 motion, which I believe it is a Rule 30 motion, filed a notice of appeal, but then never pursued his appeal and instead filed the 211.3. So I think this can be easily dismissed based on the fact that that Mr. Fitzgerald did have alternative appellate remedies for this matter.
So what has happened to his pending appeal with regard to the Rule 30?
His pending appeal, he's filed a notice of appeal, but nothing has happened since then.
It's, when you say Rule 30, maybe it was Rule 30, but that's what you're talking about is the motion to vacate the plea and reimpose sentence?
Correct. The way I read it and the way Judge Spina had read it, it's a Rule 30 motion to vacate his guilty plea based on improper involuntary medication. Mr. Fitzgerald appears to be arguing that the process wasn't followed properly. But I think even if the court wants to reach the merits of that, it's really a red herring because Mr. Fitzgerald did plead guilty. So I think the only question before the court is, was he competent and did he plead guilty voluntarily and intelligently? I don't think there's any dispute he was competent. Mr. Fitzgerald says he was forced to be made competent by being involuntarily medicated. And he makes no allegations that he didn't know what he was pleading guilty to, that he was under duress or coercion, anything like that. So I think even with the merits of the case, the only thing the court can look at is the validity of the guilty plea, which Mr. Fitzgerald does not seem to challenge.
So how would he get relief from having been declared competent or incompetent without his presence?
That, Your Honor, I think is very unsupported from the record. I think that's why this should have proceeded through the trial courts. There was no opportunity to establish a factual record. We pretty much have no record on appeal here. The appellees weren't allowed to file anything before Judge Spina ruled on this motion, so all we have on the record are a couple of random pieces of paper, so I really don't know if he wasn't present truly at a determination of incompetency. And I don't think the record establishes that either.
Did Mr. Fitzgerald have counsel at any stage of the proceedings where he's trying to undo what's been done? Are you aware of who was representing him?
All I can tell from the record is, and it's, I believe, on page 1 of the impounded record, it's a handwritten notes of all the attorneys Mr. Fitzgerald had over the course of this proceeding. I think it's unclear. The only incidents I can see that Mr. Fitzgerald has tried to challenge his determination of incompetency and forced medication is this, what I'll call a Rule 30 motion to vacate, which I believe was pro se. But other than that, through this entire process, he was represented by counsel. I don't think he's made an argument otherwise, and I think the docket indicates, and it's presumed to be regular, that he did have an attorney. He did go through a colloquy, which I would assume a judge would make sure that he had the assistance of an attorney for his guilty plea.
All right, thank you.
If there are no more questions, I'll rest on my brief. Thank you.
Thank you.